Is it visible? My share the screen, that part.
Yes, you're visible.
Okay. Okay. So last sessions, that one query came regarding that part of that how we can convert that class notes in the terms of the copyright. So in these cases, I just projected one copyright already approved, granted from the government of India. This part. All we are using the Google Classroom. I think people, they are giving the easy to access all the type of class notes, class activity. But the Google Classrooms, that one small part is you can design for the grading terms of rubrics. So existing techniques, existing technology are available. Just you try to link to your subject matter solutions. That also you can copyright. That in my current college, one TLE department is there, Teaching, Learning and Enhancement Cell. They apply the copyright in the terms of how Google Classroom or Google activity, what exactly they are giving for the terms of class notes, assignment, marks distributions, grouping concept, group discussions, all the things, how you can design the rubrics forms, that also you can go for the copyright. Another one examples, I want to project it that that every colleges, every institutions have different type of curriculum activity in an entire year. They have a proper plan of that guideline. I think few colleges, few institutions, they are modifying after 3 years, after 5 years. So in these short durations, if you can plan a proper curriculum design for that coming 3 years, coming 5 years, so that models also you can go for a proper copyright mode. Very simple things that you can design that way your curriculum activity in 100 marks, 20 marks for the particular this assignment, next 50 marks for this online exam, another 50 marks for the offline exams. So what exactly you are design for the entire administrative work as institutions, that also you can go for a copyright mode. Another one interesting copyright in entire India, only Christ University have unique holistic education's concept. Basically, every colleges, every institutions as an engineering department, they are provided technical knowledge. But in Christ cultures, we are trying to provide every semester one subject should be the holistic educations. So when AICT approved this subject, so then we started to applying the copyright. Few copyright, they have lot of clarifications review. After the 7th review, they accepted our proposals, and it is approved that holistic education techniques, you can involve your engineering students, basic science students, any university students, how they can improve proper enhancement structures in the holistic educations. That also already we copyrighted in the terms of holistic educations. Another one, small examples of we can provide that part that we know that in all over India that are big problems for the women's educations. That last few years we are working for that models. So if any class teaching concept or a classroom idea, how to improve the female students environment, females educations can be improvisations, that also is the always welcome, because government of India have one policy in the IPR concept. If your application in the terms of the women's empowerment, women's health issue, women infrastructures, women's educations, that is 50% time should be minimized, that you have to go for the first review process, first execution process. So this type of process is there to overcome your entire research in the terms of the women's empowerment part. Before you start for any type of patent or copyright, few people, they have that lot of confusion, the fee structures. The fee structures means in the terms of that how many forms we have to upload in the terms of the terms of that particular mode of the patent application forms. Anyone please discuss? It's my Google Chrome is visible.
Not yet. Not yet.
because suddenly they need a permission. So can you give me the permission for that sharing the screen?
Yes, you're co-host, so you should be able. Can you try one more time?
So I have to. 1 second, I have to rejoin. Then I can do, because I think maybe some issues is there. 1 second.
I can make you. Okay.
Before you go for that patent copyright mode, it is very easy if you go for that this link, that IPR India, because in the patent or copyright, in number of forms are there. It's very confusion. It's very difficult to understand which part you want to apply. Before start any patent copyright work, if you go for this website, all the details, informations are visible with the fee structures also. And for the patent, apply to granted, awarded, total 30-35 application forms is there. That is very difficult to understand. For that solutions, that another options are available if you go for in the WIFO, because this is the one data set where in number of informations you can easily available in the terms of patent or copyright or any IPR related work. Very simple thing. If you want to go for your kids admission school, you have a daughter, son, or you have a brother, sisters. So basically, minimum 3-4 school you have to visit it. You have to observe. Then you can discussions your family member. Then you can take a decisions that I can put my daughter, brother, sons, or whatever in a particular school. The same concept for the patent IPR before filing. All work is already done. Please go for the WIFO portal for the patent or copyright search. This is the very interesting search engine. You can go for particular keyword base. You can go for particular subject base. I just give you the one small example. You can go if you go for any particular person's name, automatically all the n number of patents are whatever type, whether it is copyright, patent, trademark, all things will be available. That analysis is the important part. What exactly they are giving in this particular website. That country wise, how many country I apply for that a particular mode of that patent or IP or copyright. The important thing is IPC code. This code you have to remember, because you have to design your patent copyright, which code you want to apply. Because if you survey few three patent, you can understand what type of particular part of that code you have to apply, because this is nobody will help you. Because if you go for any patent agent, they will design the code which is applicable for their profitable purpose. And another dangerous part is that if you discuss any patent with any patent agent, maybe a chance you apply for 4 claim, they will sell 2 claim to the others, 2 claim for you. So this is the more dangerous. So before you go for any patent agent, you think 100 times. So this is the one way you can find out that how many current patent or IPR related in the environment of WIPO. I just give another one example, because this is the most essential research last few decades. If you go for this concept of that normal watch, because every students, faculty members, every people, they are very like to purchase a watch, and what type of research is going on in number of country. The most effective result that China, they are every month they are applying for new watch related research for the patent, and the code is the 04B. So this is the particular industrial oriented product where you can apply for particular watch. So if you are any research in the terms of the watch related any research, you directly link for this particular code, because this code you have to categorize in a proper verification purpose. If you mismatch your code with your research, maybe your patent or copyright will be rejected. So here you can easily understand that which country going for the particular research part, which date that you can conclude that 2018 we have maximum number of research in the terms of patent filing. But Now it is going to the minimize the rest of the years. So you can conclude that okay, this is not the current trends of the watch research. So that way you can predict the few theoretical part to convert it as a practical mode. You can go that level also. Now go for the next sessions. I just request all of you, please, maybe you are in laptop or desktop, or you are in the mode of mobile phone. So I just request you, please open a new tab. Just type the menti.com. The code is 75196. You just try to open menti.com. The code is that 75196. One question is because after the first sessions, few people have a lot of curiosity regarding the IPR. So my question is, which topic, which area or concept you want that, yes, I can be linked in the IPR mode. So I just request the audience, so please open menti.com. The code is 75196. So I can easily understand what exactly the people they want, which mode they want to apply, think their mind in the IPR mode. So I just request the people, please give the answers. Please open menti.com. It's both will be applicable in the mobile phone, desktop, laptop. Just open a new tab. Write menti.com, menti.com. The code is 75196. I can wait for 1 or 2 minutes. I just request the people, if it is easy, if you give some answers. Okay, already one people or one audience participates successfully. Just few informations from the other audience. What exactly you want? What the first keyword? What reflected in your mind in the terms of IPR? Yes, I have few different type of concept. Yes, I have the different type of informations. I can be copyright. I can be trademark. I can be patent. I can be protect our idea. You can think that you have a uniqueness because that one of the students he gave me the answer that said I know how to control my teeth after the food. That means brass concept. So that also next month we are planning to apply for the copyright. So this way, what exactly topic area in your mind? I just request a few audience, please. Yes, the second audience also give the informations. Very good. 3 people are participated. I need few more. Yes, please open menti.com. The code is 75196. I can wait another 1 minute, 1 or 2 minutes. Wait first, my dear students, my dear audience, respected faculty members. I need your participation in this mode. Please try to control this type of idea, that what exactly idea you have in your mind, that you can be go for protected in the terms of IPR, in the terms of the copyright or anything. Solicited physics, lecture notes, electronics, design idea, terahertz research, microelectronics, classical mechanics. Okay, is use big domain, copyright, devices, people, mouse. Any other answers? I need another 2-3 people. Please participate. Okay, lecture notes is maximum. Give the answers. I can wait another 1 minute.
Menti.com.
Yes, menti, MENTI.com. The code is 75196. Do it fast, my dear audience. I can wait few minutes. Another 1 minute I can wait. Which topic, area, or concept you want for applying for the IPR mode? Mathematical physics is very interesting topic. Solar cell, okay, a number of work is going on. lecture presentations that are under of the lecture notes. The 10 people participated. I can wait 30 seconds more, not more than that. Eleven people successfully participated. It's very good.
196.
Do it fast. The code is menti.com. Link, the code is 75196. So exactly what the audience want in the terms of IPR, so that we can reflect it in this particular activity. Films, also another interesting theme, films, okay. $15 people participated. Okay, now I can go for that. My part. Okay, thank you for participating your ID in the terms of IPR mode. Next, I can convert it that part of the trademark, because this is also another important role in the mode of IPR. Because sometimes few people, they can think that trademarks means always in the terms of the company related issue. The big people, they can apply for the trademark. Sometimes few people, they can consider that if I have no business, how I can go for the trademarks? All are wrong answers. Yes, trademark started the concept of in the mode of that if you have the business policy, if you have that the terms of originality of the product, you can go for trademark. That the first example in your mind, that now we are fighting for that COVID-19 vaccine. So Pfizer is the most world famous trademark company in the terms of that protected their idea, because they are trying to invent different type of vaccines, the medicines, that trade secret they are protected in the terms of trademark. The taste of Coca-Cola, the particular that in the Coca-Cola, what different type of product are available, that also you can go for the trademark concept. But in India, the trademark you can put in the 5 different module. One is words, what exactly keyword are available. Sometimes few people just down of the logo, that Pfizer, if you observe, life is our life's work. So that type of keyword words you can go for trademark. Similar type of concept other company cannot be copied from you. Design or logo, that both are the same part of the things, you can go for the trademark logo design. Why it is so important now are the institutions, because we believe that every institutions have lot of activity. Maybe it is annual functions, maybe it is the convocation process, maybe it is annual audit program. So these type of every programs, few institutions, they have the unique logo, unique design to represent their particular programs. The FAST, that every college's hackathon competition, the FAST online product competition is there. So that every programs, they have the unique particular logo. So that logo design, the first before publish anywhere, try to apply for Indian trademark concept. What is the benefit? Already you know that as institutions, they are getting the 15 marks for that, all the process, the trademark process in that NAAC, NBA, or all the things. Another advantage is that if your any activity have the trademark logo, the promotions of your that particular programs is very easy to apply for the funding. That company people, maybe they can sponsor to your programs. So that activity you can encourage with the help of this trademark concept. Some sound you can be conclude in the terms of that trademarks, but the sound should be that not more than 25 seconds. That's the one criteria, is that you have to conclude or enter the sound, you can be trademark in the terms of 25 seconds. If you think that why trademark is important, just to imagine the few company within few decades which level that trademark value This is not the value of their share market. This is not value of their profit. The trademark value, the symbolic value, the design of this particular logo, which label they converted. Just you imagine, if you want to purchase, I want to purchase the Microsoft logo in my product, you have to give that $92 billion. That is considered using the logo only. It's not their product. So that label, the trademark, they converted in this situation. So today, if you start any logo design particular product basis, maybe after a few days, it will be used label. That in India, one famous trademark concept in that one IIT Kharagpur, they are creating the hackathon competitions every year with the link of Microsoft. That program sponsorship start from that 54 lakhs, the last year's situation. So just imagine their normal programs of hackathon, they are using the trademark logo of this particular hackathon. So that level, that increase the quality of and the cost of the product in that level. The previously that this is the 15 scenario, that 15 to 18 always Apple and Google is the first and second positions, Amazon third positions. Then previously it was that Apple, Google, and Coca-Cola. That Amazon in seventh positions, eighth position. So not that much that always that somebody should be the first. It depends on your trademark value also. You can improve your company level. Why trademark is important nowadays? The goodwill associated with the products, because sometimes if your product is very good, companies rise in their respected profitable part, so it should be the proper trademark. Trademark also the essential to reflect that which level of the trademark, that means which quality of the product are providing from your company. Sometimes the few ownership also the difficulty to got a trademark, because as previously trademark can be applied for any individual persons. Now it should be the department, now should be the organizations, or under the some common of the peoples. The single people cannot be applied to the trademark in India nowadays. It should be the combinations roles of organizations, department, or the group of persons. There's two important parties, that one is goods and the services. What exactly the trademark reflected the service provided, the customers, the shareholders of your particular product, how they're using of these particular things. It is good services or the proper effective services. That also all are things nowadays reflected in the terms of trademark. Few confusion is there, because when I also want to purchase some product from the company, as a Indians, the first conversion done by the glucose D and glucose D, that both company they book a trademark in the terms of similar type of keyword, kindly similar. Another example is that Delta, one of the product for that my microchip, Delta one of the product for that hotel, Delta one of the product for the service provided on the website designing. So this way the few companies they are intentionally trying to convert their trademark which exists in good trademark policy. Before 2004, the few people you can apply, you can easily convert it that level, but now it's completely blocked. 60 to 70% keyword you cannot use from the existing trademark logo or trademark keywords. You are not allowed to use the similar type of registered trademark in the new things. It's create the confusions in the terms of the marketplace. It sometimes that right to the consumer to give a complaint in this particular mode of the trademark. And your establishment also be a not proper roadmap if you are similar type of product are trying to trademark. So any type of logo keyword you can combine, apply for trademark. Just you follow these things. That existing 60 to 70% match is not there. Okay, it should be the uniqueness should be the 60 to 70% of the existing trademark logo. Then only you can go for the trademark purpose. Lot of tools are there, because we know that that sometimes as a students, as a academicians, as a insurance people, it's not easy to go for the trademark procedure search tools. So how can you get the solutions that previously it is there or not? So few effective knockout searches are there, full availability searches are there, and investigations in the proper manners. These three things are the most important search tools which can provide the proper trademark. The one examples, few people they can think if the trademark in Canada, if it's trademark in Australia, I can be easily apply in India and get the granted. Is completely wrong, because nowadays all the trademark have the centralized system, just like a WIPO. They process all the similarity, and if you 60 to 70% the similarity, they will reject your applications. So this one website is there, ic.gc.ca. That is basically you can apply for any Canada type of activity in the terms of trademark logo. You can easily get the all informations of existing techniques. Another things, one US Patent and Trademark Office, they also, it is openly applicable for all the informations existing, applied, going to be filed, going to be applications and awarded. That 4 level they have categorized all the things, trademark stamps. So that also you can go for getting all the informations before applying in India as a trademark. Trade secret, both are different, because sometimes the trademark, trade secret, both are linked in the terms of that process of execution, the trademark of the business policy of the company, but both are different. You cannot match, you cannot similar type of work and apply the trade secret. Basically, the information that is not generally known has commercial value because it is secret. Reasonable effect taken to be maintained secrecy. Very simple things. We know that KFC, the KFC taste, the particular sauce taste is completely different. What exactly procedure to create this particular product? The taste of KFC chicken, that is completely under the trade secret. Last few years, all the medicines, all the vaccinations, sometimes all the baby foods also, baby food products also under the trade secret mark. So similarly, if your hostels or college, because last year we got an application from the South India one college, they are giving a one type of suite in their college hostel students, so who are staying in the college hostel. So that suite's informations they apply to the trade secret. So this type of directly you can apply, your institutions can apply in the terms of the trade secret if it is multiple people are accessing in this particular mode of the product. That example trade secrets in the terms of that if you have that very unique formula that is applicable for this different type of food product, business plan strategy, that is I can link with that. Every organizations have a strategy to complete the entire 1 year curriculum activity, that you can go for the trade secrets applications. New product name, that all type of new name also the part of the trade secret, because you cannot give that normal trademark concept in the terms of new name. The marketing plan, the unpublished promotional materials. Basically, when we are applying for any advertisement or any modification part of the existing product, that is called promotional material. But if it is unpublished, so before published, you can go for the trade secret. Actually, basically, the most of the people they are giving that the first difficulty of that IPR of India, that we are very much familiar in the social media, that is maybe Facebook or LinkedIn or the WhatsApp. So now the last 3-4 months, the IPR have one policy that before publish any patent or before apply any patent or copyright or trademark, if anyone put in the social media, it should be rejected. I give a small example. Today I apply for one patent or copyright, and it will be take 30 to 60 days for all the procedure, approval, online coming, all the things. Before that, I put in the Facebook, I am so happy, hashtag, my first patent apply, hashtag in the topic. If the topic of the title of the patent or copyright is similar to the any Facebook notifications, Social media notifications, 100% your copyright or patent or trademark should be rejected. I repeat, before publications of any IPR policy of India, please don't publish in the social media. Any keyword mismatch with your name, immediately they will go for the completely rejection process. Cost and price information. This is the most important thing, that what exactly type of product cost will become. Because if you think that I want to launch a product in 20 rupees, is existing is 55 rupees. So is a less cost. Huge number of people can purchase my product. So lot of policies is there, lot of trade secret are there. You have to follow all the rules. Then only you can go for trade secret in the terms of cost, pricing, and information. Sometimes that few years before that in India government they have a revolution in the terms of that toothpaste. The different company toothpaste are available, but the toothpaste cost, the few company 20 rupees, few company 70 rupees. So how this much difference is that? Then they put a rules under the trade secret that every product cost should be this limit. So that also in the terms of trade secret policy. Sometimes the output of the sales data, financial projections also you can put under the trade secret. The customer list, all banking sector customer list you have to apply, strictly follow the trade secret policy. And I think within next year the AICT put rules that is the meeting is going on, that regarding that all the students informations, because previously students means name, roll number, maximum phone number and marks is there, but nowadays students information means entire things, Aadhaar card number to their parents Aadhaar cards, because they are submitting the fees in the online mode. So student list huge informations. So every college responsibility to protect that information under the trade secret. It will be process is going on. We can expect that within 1 year, that is also it will be another trade secret policy, that every student's information can protect with the terms of institutions. The new business opportunity, that also you can apply for the trade secret, because sometimes few company that you can, that 20 years before that money market business not that much, that chain business is not that much, but few years before it will be huge demand, huge people can be linked. So that idea you can convert it as a trade secret policy. Advantage of trade secret is that never expire, because trade secret have that 100 years, 200 years. I think one US trade secret has 1.55, 155 years is already overcome. It's now also going on. So this type of protections, that promotions, protections, you can go under the terms of that trade secret modes. There is no government approval is required. This plus point, that sometimes whatever you want to do, you have to got the approval, you have to got the NOC from the different type of layer. But trade secrets, no one give the approvals, directly you can apply for that. And it's very easy to get approval, because I think more than most of the trade secret, 100% they can secure, they can process in the terms of the acceptations. The example Coca-Cola, the KFC food, and sometimes in different medicines also you can go for the trade secret mode. Some drawbacks also is there. It's not, don't think that always there is a positive or an advantage. The big drawbacks in the mode of trademark is that basically, if there is secret is there, so people always they try to learn. People, the people mind is more curiosity. So this type of things is very much drawbacks or difficulty to protect your trade secret. So for that reasons, that lot of policies are there, lot of security processes are following nowadays to protect your trade secrets. But sometimes the few people, they are habituated to collect the information if it is secure. So that is for that reason that not that much, maybe 10 days, 20 days, 1 year. But after a few days, it will be not secret, that people will understand exactly background of this particular trade secret is there. Second thing is that reverse engineering is the another important role to stop the trade secret. Some people they are doing only that part. That in Bangalore we have one company, they are working only for reverse engineering process. So easily they can predict that what exactly trade secret are going in behind to your business. So that is their job. So that reverse engineering also are the drawbacks of the outcomes of the trade secret. But how to protect the trade secret? What the policy? Because we know everywhere the people are there, a lot of drawbacks is there, but somehow we want to protect all the things. Basically, most of the cases, the few things is followed by the maintain the computer secrecy, that secure online transactions, internet, website, all the procedures, password, access control, digital key. That is the most important thing nowadays, that every online process is controlled by digital key concept. That also few part is completely secure. No external device at USB port. Very simple thing. When I was a student in MCA level, 2007-2010, so my college put up strict rules that you cannot use pen drive in the college computers, because maybe some virus are available in your pen drive. So if you insert any pen drive in the college desktop or laptop, maybe you fail in that particular subject. So that type of fear is there. So now you can put that secret label that no external device USB port is there are available in this particular forms of the trade secret. So if not there, people are how we can send a digital secrecy in the different places. Remote access of the server, it's most important to protect the trade secrets nowadays. That with the help of the firewalls, with the help of the antivirus software, encryption process are also following to protect the government of India all the trade secret policy. But not 100% secure. Every day minimum 1 or 2 news are available that this applications number of trade secrets are rejected due to the similar type of product already available in the market. So that means all that leakages happen. It's not secure 100% to protect the trade secret. Apart from that already we have the conclusions regarding that patent, copyright, trademark. Now, the few people, few students, few academicians, maybe they can link with the industrial design. That is also an important role of IPR concept. Of the terms of that configurations, patterns, compositions of lines or colors applied to any particular activity which is linked with the mechanical device, electrical device. So that industrial product design you can apply for the copyright or patent or under the IPR. Very simple thing, blueprint of any hardware you can apply for IPR under the industrial design. That electronics department, every day they are trying to minimize the power consumption. They are trying to minimize the different type of activity in that circuit design concept. That design, that fabrications of the circuit elements also you can directly apply for IC layout design. But the problem is sometimes that these applications may not be applicable for that real life product. But somehow if it is uniqueness is there, Government of India, they can approval for that mode. That most of the applications of the IC layout design, it's controlled by semiconductor concept. What exactly requirement for the design? Maybe it is IC layout design or the normal design. What exactly requirement of that I can complete this particular protection of the things. Basically, when you apply for any IPR mode of the design circuit, that things, it's obviously a common concept that new and originality is there. But nowadays that you have to create the minimum 5 to 6 minutes video when it is activations. That means before you are writing all the application form, you write the abstract, design all the process. With application forms, you have to upload that 5 minutes video, how it is work. Your this particular microchip giving the output or not. That small video is most important to apply in the terms of IC design, because without video now they are not accepted your application form. Now, I already informed that plant variety. You can go for that applications in the mode of IPR. I think that St. Xavier's College, the Kolkata, they applied the last year one new variety plant in the mode of IPR mode. Stone plant. They gave the name the stone plant. They created or it's maybe upgraded version of the one type of plant that the growth of the plant is very less. The stone plant they apply for that in the terms of IPR mode. The biotechnology departments also directly you can apply for the lot of inventions in the terms of that microorganisms cultures. So that things you can apply with the IPR mode. It's not the similar type of patent or copyright, but it's a different categorized in the terms of only biological research in the terms of biotechnology inventors. Traditional knowledge that I already told in the last sessions that that one small village in Kerala, they have the sounded in the terms of that Om sound. That sound they apply for that IPR and it is approved also. Similar, if any type of knowledge developed by that particular local communities, maybe it is zone wise, maybe it is rural environment or city environment, particular local community for the use of our natural resources in the terms of agriculture, food, medicines, all the things. That particular period of times, you can apply for the traditional knowledge. In this traditional knowledge, we applied that in our college, we have a holistic teaching techniques that we applied for the copyright mode already approved. A similar time, if your environment, your institutions, because sometimes some colleges they have the unique prayer. So that prayer sound also, that musical sound of a prayer, you can apply for the traditional knowledge in the terms of IPR mode. This is interesting things. I think India have in number of unique identifications in the terms of geographical indications. As we are Indians, we know that the different type of variety food, different type of cultures, different type of concept are available everywhere. So that you have to observe and find out. I just give a small example, so it is easy to incorporate in the mode of that. In West Bengal, different type of mangoes are available. That the different type of name, different type of taste, different type of colors. And I am staying in Bangalore. From Bangalore to 2 hours journey in Karnataka, one small village area there is there black chicken. Everything is black. The blood of that the chicken tends to the black. Also the meat, the muscles, all things are black. So it's completely different type of chicken, black chicken. So this only available in this particular region. So if you have any type of particular indication that any product, maybe it is agriculture based, maybe it is natural goods, or sometimes you can observe that its particular product are available only for that particular area. So if that cases, it's very easy to apply for IPR mode, and it is only applicable for individual applications, not any organizations, not any institutions. Individual mode with the affiliations of the institutions can apply. This is the one drawback is there, that exactly if any persons they can create a particular product. After the few days, the entire regions that product is available. So who will be applying for that? So in these cases, they put the official rules that single invite applicant can apply for this particular mode of IPR with the help of institutions affiliations mode. This is the very two examples that black chickens in India, it is nowadays it's really effective profitable part. Most of the mangoes also import export business is going on in India, so that already it is granted approved by under the Indian IPR. Now, what is the difference? Because now you have the idea of the patent, you have the idea of the copyright, trademark, trade secret also. Now the question is, which can be applicable for my research? Which part I can apply for that? If it is product based, if you saw any hardware parts, inventions, directly go for patent. Don't go for copyright, trademark, trade secrets, anything. Directly you can apply for the patent. Patent is applicable for the 20 years only. New method should be followed into your patent. If you have the copyright part, that is before start the research, lot of people, they're collecting the survey report, they're collecting the informations, all informations you can apply for the copyright. So you can design your entire research in that mode, that we are planning to involve in our institutions in that level, that as a PhD students, before publications of any research papers, you have to apply for one copyright. If copyright is approved, you can go for the patent design applications. Then you can go for publications. So previously, the few organizations, they thought that yes, if it is 2 Scopus, 2 ACI, you can submit thesis. But last few months, when we are discussing the lot of improvisations of the AIST norms of the college infrastructures of the policy, there are few people, they suggest that yes, we can plan that way, that as a students, when they are review the papers, collect the basic data set, collect the basics informations, so that pre-publications report they can apply for the copyright. If copyright approved, you can apply the design of the patent, not completely used. You can design it. You can apply to only design part. Then 4 years time is there. You can design the particular product and you can apply for the patent. After apply the patent, you can go for the publications. Because if you go for the publications, then copyright patent in the same topic, 100% will be rejected. This is the only drawbacks for the Indian patent process. The trademark, basically, if trademark, trade secret, basically service provider. Maybe it is institutions as a service provider for the students' perspectives as a business policy, or any nowadays that in India quota environment that means near Rajasthan of that area, the few coaching center, tuition environment peoples, they apply for trademark of their technicals, all the content. For the trade secret policy also, they are applied. The few people, they are working previously in the Pathfinder or nice in different type of companies, but after left the company and they create their own teaching environment with the help of copyright, trademark, and trade secret policy. So trademark, trade secrets is you can predict that it's going on. It's a continuous. As long your business, as long your service that you're providing, there's no year restrictions. Patent for 20 years, copyright for basically ultimate applicant, how much your age. If your age is 70 years, so it is 70 years applicable. If your age is 100 years, 100 is applicable. Date of the applicant, the copyright is not applicable. This is the policy of all the Indian copyright or trademark systems. If you go for that where I can get the informations, because if you run for the patent, copyright, or any trademark policy, you have to observe more, you have to survey the more, then only you can do this one. So a few important links are available. You can go for IPR India, all the Indian product, maybe patent, copyright, trademark, IC design, all the things are available inside the IPR India. IPR Service India is most important, who are already trying to modify the existing patents. I have 2 patents now few years that there is no profit will come. I have to reframe the claims. So that type of activity you can go for IP services, that website. Apart from that, Rajiv Gandhi National Institute of Intellectual Property also can provide you that information which is applicable for that horticulture, agriculture, that type of patent related activity. That is the most important information are available there. Patent search, copyright search, or IPR search. That is the important things. What exactly search engines are available? Because if we know the existing policy, then only we can improve my techniques on the process. So in these cases, the first I can provide you that INPASS, that Indian Patent Advanced Search Systems, is very informative data are available, effective data are available, comparative study also available parallelly. UIFO is another one that is all over world. Maybe it is India, Australia, US, Canada, all the different country people informations are available inside the UIFO, which we are centralized data centers who are providing n number of countries patent, copyright, trademark informations. Sometimes few product, few activity, few research only for European country. So they have the different type of patent informations, different type of patent search engine. In European Patent Office, patent search also you can try to project it that level that if your product you think that I want to sell, I want to provide a good company labels in the mode of European countries. So you obviously go for that particular patent. We know that is a wonderful search engine is Google. Google have owned their patent search. Google patents all existing country, all existing approved labels, published label, and that apply for examine. All type of patents are available in the terms of Google patent website, the patents.google.com. And last but not least, sometimes the few IPR India website can provide you the last few months. Not all the patents are available. The last few months, last 6 months, how many patents are approved? Their information you can directly download from that IPR India online mode. So this is the huge data server, huge process, which is applicable for the mode of that search engine, basics informations, existing process, and what trends is going on. Because if you understand the trends of this particular part of the subject, you can be easily involved in this mode of patent copyright. Now I expect few query from the audience. Last half an hour, I want to happy to discuss more in the terms of patent, copyright, or the trademarks. So I expect the few query from the audience. You can put the chat box, or you can go for unmute options also.
Thank you so much, Debabrata. I mean, it's very interesting, and I actually came to know a lot of things which we had no clue about. I'll have one question to start with. That is, as you mentioned, like the copyright or IPR is linked when it's like filed by a person. So it's valid until the life of that person. I mean, like, so, I mean, intellectual property is something that you cannot inherit, right? So your next generation cannot have the IP if their names are not linked with it.
Yes. Actually, I think 2003, the big news came in Anandojit Putrika that I think every people study that particular mathematical subject, that K.C. Nag. I think every class they study the K.C. Nag particular subject. So after the death of the K.C. Nag, that their family member, they apply for that royalty of these particular books. So then Government of India, they prove that it is not applicable. After the death, the copyright part is stopped. But if the copyright applicability part you apply to the patent, it only for 20 years. That means 70 plus 20 you can extend. But last year you have to apply for the approval mode. If you go for the other part, not patent, not copyright, if you go for IC design, if you go for that product design process, the terms of patent forms, that is patent design, not utility patent, design form of the patent, that is in number, next generations can get the profit. But how many days that you can, that safety pins, I think more than 100 years they are getting the profit, royalty is getting that part. The safety pins is not replaced by any other different design. So if your product are that level, so first basics, then you can go for copyright. After that same copyright part, you can go for that design patent. If design patent is very applicable, go for that last year registrations. So last year registration means claims should be different modification part. Again, you can extend for the next generation purpose.
Right. Perfect, Debabrata. I'd invite someone else. Anyone has any other doubts? We can take some time and clarify here.
I think few people they are raising their hand. You just observe that part that you can give the permission for the unmute, because few people
Right.
they are ping me but not coming in my screen. If any query, please put in the chat box, or any confusions, you can raise your hand. We can give that unmute options. Any query, any confusion regarding that entire IPR process. If any doubts regarding that which part can be copyright or cannot be. Any query from the audience?
All right, let's allow some more time to sink in. I think I'll ask one more question if
Yes,
that's
sure,
fine.
sure.
Yes, it's more about the design patent part that you mentioned. So, say what I have is only a design. I have a thought. I mean, I'm planning uh, a so it's very much in my mind, the design, and I can probably not have any simulations because some of the instruments that we deal with requires a lot of sophisticated simulations. But I still want to file a design experiment. I mean, how do I justify that?
Okay. I just give an answer with the proof. My screen is visible?
Yes, now it's visible.
Okay. So one computer science faculty, he started the research to create a electronics lock. That product already be ready, but we told that please don't go for patent directly. First, the concept we apply for the copyright, it is approved, and they gave some modification part in the part of health issue or that social impact. They also they gave this is basically low cost of electronic lock. Basically, they have the idea to implement. So before go for patent, I told that please go for copyright. That's approved. Now this month we applied for design patent. That not for the product patent. What exactly that electrical design part? What exactly power consumption model of that role? Only that diagrams we apply for the design patent. If it is approved, then only we can apply for the product patent. So these three levels. So I think if any company, why they want to purchase your idea for the royalty purpose. So if you projected that level, copyright, patent design, and the patent, these three different view, if you link with your work, I think easily good for in number of years, maybe 100 years, you can get the benefit. Maybe one company, they want only for copyright mode of that part concept. One company, maybe they want only for design purpose. One company, they want entire hardware. So in this way, you can improve your entire things in three levels: copyright, patent design, and product-based patent.
Excellent, Debabrata. I don't see any more questions from audience. So I'll
Any
take.
query, any questions from the audience?
No, I think what happens is like, I mean, I hope that we will have more questions and queries as we start actually working on this. And
Exactly,
you
exactly.
understand, like many of our audience and our colleagues will probably be reaching out to you for help and support as they want to file in their IPs. I mean, like, because this is various subjects that we have, so it'll probably start coming in sooner in few months' time, and they will probably be reaching out to you. And so I think it is more or less for the technical part. This is very interesting and very useful today. So thank you so much, Debabrata, on this one. And
Okay,
I
one second,
right.
one second. I have that another main part because lot of people they have doubt that if any technologies are available or not to complete my entire patent work. Because sometimes some technology maybe help you to write the drafting of the patent or copyright. So my last sessions, it should be concluded with the help of that part, that how technology can help you to complete your entire patent or copyright drafting process. Because few people they always know, but sometimes it's a compulsory to give the information regarding that. Few part we jot down that always you try to write your applications in the terms of the patent copyright. Go for the latex is the best. Apart from the Google Docs, also you can go. It's a group work. Sometimes Open Office also is very easy for this one because sometimes Grammarly software also they can link and you can modify your Grammarly part. So for the writing tools, you can go for this particular software. You can take a helping hand. You can note it down. Depends on your activity, your expertise. You can access all the things. Reference. Copyright without reference is most dangerous. And reference, it should be the proper process. If you go for any reference management tools, always it's very easy if you go for that. Any proper that copyrights their own one management tools is there. It's very interesting. So directly all reference directly linked to the copyright process, because we know that any research papers have different reference mode, and if reference is not proper, good writing article can reject it from the reviewer from the publishers. So that also followed in the here IPR concept. You have to give the proper referring process using these particular tools. Sometimes some comparative study you have to explain in the terms of graphical representations, that you can give some comparative study in the mode of pictorial representations, tabulation forms. You can conclude by the Microsoft Excel's auto process is there, that inside the Google Doc. If you link with the Microsoft Excel, the lot of features, statistical features you can represent it. That also you can represent that way. Plagiarism is the most but in my institutions we are trying to process that if you follow the ethics, that plagiarism software is no need. If you start writing in your own words, it's no need to go for that process to check any plagiarism part. That if you conclude in the mode of that process, that some tools can be modification part only, you can go for this patent or applications in the terms of IPR. Apart from that, if your creation is very good, you can go for any IPR process. And another important thing is that what basically, because few people have a lot of idea, but they have the confusions how we can start the basics research in the terms of IPR mode. Every college have different policy. In my institutions have one interesting thing is that we are trying to put some adaptation concept in the different colleges. If you have that 2-3 faculty members, 5-10 group of the students, people that are interesting for IPR, we just put official mail to our institutions. We can train you for 6 months, that from the zero level to expertise of that IPR mode of patent or copyright writing skill. That all the levels we will providing the helping hand in the drafting, filing, examinations, how to apply for the examinations, how to write the proper examinations answers, and NOC process, because lot of level are there to get the NOC, because previously the students name is different, address different, the department different, so that all level step by step NOC is required from the institution level. That NOC how to submit, how to provide is the most effective rules of the copyright. The last year 34% in copyright is rejected only for not submit the NOC in the proper format. There is the security rules of that. So that all the process we can provide you. Just if your institutions, any group of people, if you want that in number of patent, copyright, trademark policy, any help, just put an official mail to us. We will definitely help all the process executions and step by step. So obviously, I put the official thank you to all the audience and institutions to give me the platform to executions all the process. And we expect that if you have any doubt, feel free to communicate to us. Just put the official mail to us, and we can give you the in number of solutions regarding the filing process, writing process, and effective process. Maybe some patents not applicable for India. It's maybe applicable for the US or Canada or Australia, because now few days Australian patent is very easy to applicable for the apply filing. Only for 25,000 cost is required to apply the Australian patent. So this way you can be an Australian patent. Other advantages, within 30 days they'll be given granted if your product is ready. So is the plus point is that, so that way you can process that is maybe not in India, which country I can apply for this particular IPR mode. Always welcome. We will be helpful for that in this mode of the IPR process. Thank you all. Any query you can communicate to me or unmute or put the chat box.
Right. Excellent, Debabrata. Thank you so much for the expression of your support, and we look forward to collaborate with you further also. I'd like to personally thank you for today's session and all the efforts. I mean, like it's almost constantly 3 hours. And I'd like to invite in our convener, sir, Chandrachur, sir, to like express his feelings and give the vote of thanks.
Thank you, Amit, for your very nice coordination. We have reached the culmination stage of our today's second e-workshop on intellectual property rights. I feel very proud and privileged to stand before you to deliver the vote of thanks. At the very beginning, I express my heartfelt gratitude and my polite appreciation for our honorable principal, Dr. Falguni Mukhopadhyay, sir. He has given us a marvelous inspiration and moral boost so that we can conduct this seminar. Our esteemed speaker, Dr. Debabrata Samanta, Assistant Professor, Department of Computer Science and Coordinator, Patent and Copyright Cell of Christ University, who in spite of his heavy enlightened us with his regular speech. His speech was really fascinating. It was dotted with numerous vivid, lively examples, which have not only helped us in grasping the ideas, but also in knowing more about the practical processes for the purposes of the webinar. I also express my heartfelt thanks to all the participants, particularly the enthusiasts who have helped us to know more with their beautiful queries. On the behalf of the IQAC, I also express my thanks to Dr. Goutam Mukherjee, the HOD Physics, for chairing the session, and Dr. Sujit Kumar Bera, the bursar, for his support. And finally, I would like to express my love for my little brother Amit, who has coordinated this whole function. Just before I end, a little note of request from the chair of the convener. Please give your feedback form. Your certificates are auto-linked with it. Within tomorrow, it will be very helpful for us. At the end, I would also like to thank the speaker, Dr. Samanta, for his valuable time and his beautiful speech. Just like Amit, I will also request you that we will keep contact with you as we proceed in this line. We have many problems. I request you that we will disturb you in this regard. Thank you, everybody.
Thank you all. I can expect a few query or emails in the further communications. Thank you all.
Yeah. Okay. With these few words, I declare this webinar, second e-workshop closed, and we hope to meet again with our third e-workshop on IPR in the current future. Okay, thank you, everybody.